Supreme Court to hear challenge against electoral bonds scheme on October 31. The Supreme Court will hear the batch of petitions challenging the electoral bonds scheme on October 31st, 2023. Heard the preliminary issues today. The petitioner have decided to not argue on the scheme being passed as a money bill as of now, since the issue pertaining to bills is yet to be decided by 7-judge bench in Roger Matthew versus South Indian Bank Limited. Coming to preliminary submission before court at the outset, Advocate Prashant Bhushan, expressing the need for the matter to be heard soon, stated that because of the non-decision in the matter, bonds are being issued before assembly elections. The Chief Justice of India assured Bhushan that the court was ready to hear the matter. However, the Attorney General for India, R. Venkataramani, interjected and stated that one of the issues raised in the challenge against the electoral bonds was that it was passed as a money bill. In this context, he stated that the issue pertaining to money bills was to be heard by a 7-judge bench in the case of Roger Matthews. Bhushan interjected and stated that while money bill was one of the issues raised in the plea, there were other issues to be decided independent of the money bill. He asserted that anonymous funding of political parties violated the right to information of the citizens. He added that the anonymous nature of the funding also promoted corruption, as it allowed companies who had received certain benefits from the government of certain parties to anonymously donate to those political parties, he said. Elaborating upon the method through which electoral bonds could be purchased, Bhushan underlined that the State Bank of India, despite opposition from the Election Commission of India and the Reserve Bank of India, has been designated as the bank where anyone could go and purchase electoral bonds in denominations of rupees 10,000 to rupees 1 crore. At this juncture, the Chief Justice of India inquired if the bonds could be purchased by bank transfer or through cash. He added that the same was quite important, as if a bond was purchased through a bank transfer, then the source of channel would be banking channel. However, if it could be purchased by cash, the process would be completely anonymous. Here, Advocate Shaddan Farasat, also appearing for the petitioners, stepped in and clarified on the aspect of anonymity of electoral bonds. He stated, the real anonymity is that when you transfer to a political party who is donating to which party is anonymous. The Chief Justice of India, seeking clarification, asked if a person could transfer money to an individual too. Farasat stated that only a political party could encash an electoral bond. In that sense, an individual could not be transferred the money, he added. Earlier, there were disclosure requirement for over rupees 20,000. This scheme says that if you pay through electoral bonds, the party does not have to disclose. It only has to disclose overall amount it received from the electoral bonds. He added that there was also a concomitant amendment in the Companies Act, as per which shareholders of a company would also not know which political party their company had donated money to. That way, the transaction became anonymous from both ends. The shareholders would not know who their company donated to, and the parties were also not required to disclose who they received the donation from. In this context, he stated, the information of donation is sanitized from the public domain. Money bill issue will not be argued upon. Once the preliminary issues were argued upon, the Chief Justice of India remarked, we will start hearing, but what about the money bill issue? Are you pressing the money bill issue? Because this is listed before a 7-judge bench. It's your petitioner's call. Do you want to hear the money bill issue. Bhushan, on behalf of the petitioners, stated that they would wish to argue the matter along with the merely bill issue only if Roger Matthews' case was settled by December 2023. At this, the Chief Justice of India stated, "It may be difficult to predict right now. We have listed all for pre-hearing on October 12." Bhushan then stated that in such a case, the petitioners would argue the matter without the money bill issue. The matter has been listed on top of the board for 31st October 2023. Coming to background of this case, uh, by virtue of the 2017 amendment made to Section 229C of the Representation of Peoples Act, a donor may buy an electoral bond at specified banks and branches using electronic modes of payment, and after having completed the KYC requirements. However, political parties are not required to disclose the source of these bonds to the Election Commission of India. The bonds can be bought for any value in multiple of rupees 1000, 10,000, rupees 1 lakh, rupees 10 lakh, or rupees 1 crore. The name of the donor will not be there in the bond. The bond will be valid for 15 days from the date of issue, within which it has to be encashed by the payee political party. The face value of the bonds shall be counted as income by way of voluntary contributions received by an eligible political party for the purpose of exemption from income tax under Section 13A of the Income Tax Act 1961. Accordingly, the petitions were filed in 2017 challenging the provisions of Finance Act 2017, which paved the way for anonymous electoral bonds. The Finance Act 2017 introduced amendment in Reserve Bank of India Act, Companies Act, Income Tax Act, Representation of Peoples Act, and Foreign Contributions Regulations Act to make way for the electoral bonds. The petitions have been filed by political party, Communist Party of India, and NGO Common Cause, an association for democratic reforms, which challenge the scheme as an obscure funding system which is unchecked by any authority. The petitioners voiced the apprehension that the amendment to Companies Act 2013 will lead to private corporate interests taking precedence over the needs and rights of the people of the state in policy consideration. In 2021, the Supreme Court had refused to stay the release of electoral bonds ahead of the assembly elections in certain states. So the case is Association for Democratic Reforms and Another versus Union of India. It's a writ petition bearing number 333 to 2015.